Kathleen Lahey is our closing speaker and has held the position of Professor of Law and Queen's National Scholar at Queen's University Faculty of Law since 1987 and is cross-appointed to Women's Studies there. Before moving to Queen's, she was a tenured full professor at the University of Windsor Faculty of Law and a visiting scholar at Harvard Law School International Tax Program, senior lecturer, Monash University Faculty of Law, and lecturer, Osgoode Hall Law School. Professor Lahey's main areas of teaching are research and publication include taxation, property, charter, and human rights law, women in law, and law and sexuality. She is the author of the forthcoming book, Are We Persons Yet? Law and Sexuality in Canada, and we thank her for giving us a title for our program today. I also can tell you that we will be having some order forms at the reception afterwards tonight. The book will be available July 14th. A table outside, thank you. Douglas has the order form. Now that's Professor Lahey's CV. I think I want to speak a few minutes about someone I have known for many years who arrived at Kingston the same time I arrived as a young, naive first-year law student during orientation week, which was the biggest misnomer I'd ever heard at Queen's University. I had been warned not to go to Queen's because it was the feminist university law school. And of course that's where I went. And during orientation week, I was handed a petition to essentially have the lesbian tax professor fired. And I'm not sure I ever even told you this story. I, of course, was immediately horrified that I had obviously come to the wrong university, and also gratified to think, oh my God, I'm not the only one here. And who is this person teaching tax? These were the dark ages, before we actually then moved forward at Queen's. And by the time I'd left law school, Professor Lahey had been at the very core of a massive transformation in legal education. By the time I left, there was QLAG, it was called then, Queen's Law, Lesbians and Gays. There was feminist jurisprudence courses, feminist advocacy courses being taught, and the dialogue that was going on at Queen's. We call it the heady days, those of us who survived it. But it had a major and lifelong transformation for me, pardon me, personally, and I think for anybody who went through the Queen's system since then has benefited from it. So it's with great pleasure that I invite Kathy to come and talk to us and thank her for her amazing contributions to our community and to legal education.
Thank you, Terry. I had no idea that any of that went on there. I was just so busy sort of doing my thing. Which I guess, if you believe the rumors, included inciting students to take over other classrooms and demand equal time for feminist and other issues. But it has been an amazing sort of 10 or so years in Canada. I was recently doing a little sort of bar chart to see how many cases have been brought in Canada relating to sexuality, like since forever. And it would be like one case in 1974 lost. Then a few years later, another case would be brought and it was lost. And really, the bar chart was practically flat until you hit, I think it was the year you were saying, or somebody was saying it was 1992. And then all of a sudden, it's just, it's zoomed right up there. There's been a massive amount of litigation. The success rate is now well over 50%. And the kinds of cases that are being brought, I think, are mattering more and more, which is why I was sort of incited to begin working on the topic, Are We Persons Yet? Because I guess I've been looking for a measuring stick, sort of how do we tell? We can look at what's going on in other countries, we can talk to each other and say, how's it going for you? It's going a little bit better for me, sort of, trade stories and look for other indications of how we're doing. But this is what I came up with as sort of a measuring stick for the assessment of how sexual minorities, a shorthand term for talking about lesbians, gays, transgender people, transsexuals, bisexuals, intersex people, and any other sexual nonconformists who want to join, are doing. I know that there's a problem with the concept of legal personality or personhood because it involves sort of buying into the dominant discourse. But let's not kid ourselves. Especially as lawyers, we really can't escape the dominant discourse. It has been dominant for so very long. The concept of legal personality is 2,000 years old. It's the core concept in any Euro-influenced legal system. Nothing that I've seen anywhere has come close to beginning to change the way that we think about the functioning of law or the way in which adult human beings sort of set up normative orders. The concept of legal personality, I decided, is essentially the grammatical glue that holds clusters of rights and responsibilities together. It is the way in which law talks about which people are going to matter, which people will have lives that have significance, not only on a day-to-day sort of de facto basis. Yes, we can breathe. Yes, some of us can walk freely down the street. But which human beings have lives that can consist of acts with legal significance? The difference between de facto existence and juridical or legal existence. So the concept of legal personality, to me, although it's a very narrow, sort of classical, traditionalist approach to talking about the nature of law and legal functioning, nonetheless, I think offers us a not bad way to get that kind of critical standpoint from which we can assess how we are doing with this movement that has resulted in the sort of radical transformation of the bar charts. So my position is that the concept of legal personality is essentially sort of totally crucial to the ability to function. And in order to analyze how sexual minorities have been doing, I have really just sort of looked back to Roman civil law, to the original sort of codification of what constitutes legal personality, as a way to sort of set up a checklist of how sexual minorities are doing. What is legal personality as classically or traditionally conceived? It's the ability to sue or be sued, the ability to act as a witness in a legal proceeding, the right to sit on a jury. It is the ability to be a citizen or a person who has all of the prerogatives of an adult human being in a culture. The ability to vote, the ability to hold public office, the ability to enter into a public forum or enjoy public services. And it is the ability to enjoy the private law rights of entering into a valid contract, owning property, being able to contract marriage, the right to have custody of children. It's a very simple sort of concept, but it is, because it goes to the concept of capacity to act, it is a very powerful sort of way to describe the way people function. The Roman Civil Code had a whole sort of legal structure in which some classes of people were given all of those capacities. Some of them were given none of them. Women, for example, could never have any of those capacities. Children could not have them until they became the father with the power in their particular family. Aliens could not have those capacities. And so you go down the list of people who mattered in that culture. This is a very powerful way for the legal system to allocate political status, or a very powerful way for political systems to maintain hierarchies of privilege and depowerment. So in the paper that is included in your binder, I have sort of listed examples of situations throughout the last 2 millennia in which the incidents of legal personality have been manipulated in order to maintain particular hierarchies of privilege, and not coincidentally to maintain the depowered status of unpopular groups. I find it particularly interesting that the first and most clear-cut example of the use of legal personality, or the denial of legal capacities to a particular group of people on a widespread basis, can be found sorry, in the Visigothic Code, which was enacted or adopted in about the year 450 in the Common Era. Something called the Arian heresy was used as the political basis for putting the power of the state and the power of the civil code behind the program of the government, which was to put as much pressure as possible on Jewish people to become Christian. And you read through the Visigothic Code, and every possible legal capacity was denied to Jewish people in order to give them no alternative but to convert to Christianity. Not only were they not permitted to practice their own religion, but they were not permitted to seek protection from violence, and even judges who attempted to prevent the imposition of violence on Jewish people could be subject to the death penalty themselves. So it was a complete denial of legal capacity, that is, the right to matter jurisprudentially. In the same code, you find what I have been able to identify as one of the first sodomy provisions, which had much the same function in terms of policing sexuality. And as you go through laws that have been enacted since that time, you find the same kind of sort of extreme abuses of concepts of legal personality. I've listed off examples. English law is notorious for its denial of legal capacity to women as well as to Jewish persons, minors, incompetent persons, and so on. North American law imported the concept lock, stock, and barrel when it used it as the basis for setting up the slave codes of the southern United States. And even after the Emancipation Proclamation was adopted in the United States after the Civil War came to an end, the black codes also provided for the wholesale erasure of the legal capacity of former slaves. In Canada today, we still have laws known as the Indian Act, which completely erase the legal capacity of people classified as status Indians under the Indian Act, because all of the powers to act legally are given to the minister. And people who are living under the jurisdiction of the Indian Act have the ability to de facto act, but their acts have no legal significance until they receive the approval of the relevant minister. The list of examples could go on, but the main point that I'm trying to make here is that the concept of legal capacity as it is classically understood not only explains to us why and how law can oppress unpopular groups, but it also points to what I think is the most effective direction for dissension and revolution, if we could think in terms like that. Where the capacity to act is denied by law, it then becomes necessary for the law to restore legal capacity. And that's where you find a tremendous difference between what judges do and what legislatures do. If you look over the history of what we could call the human rights movement or the movement for constitutional personhood, we find that constitutional documents play a very, very important role. But it is ultimately judges that give those constitutional documents meaning. It is judges who can read constitutional guarantees that are absolutely stellar in the way they are framed as having no effect, and it is judges who can take a simple word like the word person and read legal significance into the lives of whole groups of people. So if I had to choose, I suppose I would choose looking to the judiciary ultimately as the place to try to find some sort of long-term protection for the legal capacities of people like sexual minorities who have historically experienced so many different forms of jurisdiction, or sorry, so many forms of discrimination that is justified by their lack of legal capacity. Now, Judge Epstein said something earlier today which I found very striking. She said that she was not sure that lesbians and gays should necessarily seek access to all the same rights as heterosexuals. And I think that's correct. But I'd like to distinguish between legal capacity and rights. If you don't have legal capacity, then it doesn't matter whether you can get your hands on some right or another. Without capacity, there's no right. Think in terms of legislation that deals with, for example, incompetent persons. If a person is found to not have capacity to act significantly in law, then they will not, therefore, have any rights. So, taking a quick look then, using this sort of jurisprudential measuring stick to evaluate what has happened to sexual minorities in Canada, I'd like to just make the following points. First of all, I'd like to just look for a couple of minutes at how the denial of legal personality or legal capacity has been accomplished in Canadian law. And I would say that this is not unique to Canadian law, but this particular overview, I think, fairly reflects what has happened in Canadian law. There have been two judicially promoted presumptions that have lain at the heart of the legal incapacity of sexual minorities. The first is the presumption, and this is a variant of the Arian heresy, if you like, in that it's a presumption that morality should drive state doctrine. The presumption that there's something inherently immoral about same-sex sexual conduct, the immorality presumption, which continues today to the extent that same-sex sexual activity is still criminalized, can still lead to criminal liability if it is not carried out in private. So the sort of privateness of acceptable same-sex sexual conduct reflects the continuing vitality of this sort of immorality presumption. The other presumption is something I call the heterosexual presumption, and I think probably we have someone in this room here who's borne the brunt of the heterosexual presumption in her own life. Biological findings, so to speak, made by courts have been linked together with a sort of vague sense that legal capacity has to follow biological capacity. And if same-sex couples do not have the biological capacity to reproduce with each other, then they must not have the legal capacity to form legally recognized relationships. For example, the Karen Andrews case. So the presumption that a person may include a woman, but that a couple cannot include same-sex partners is reinforced by looking to these so-called biological findings to sort of insert this heterosexual presumption into law. And if you read the earlier cases that have been decided in Canada, this heterosexual presumption that sort of goes back to this sort of biological assertion really sort of runs through all of the cases. Many of them cases to do with relationships, but not all of them cases to do with relationships. Now, another factor that has resulted historically in the erasure or impairment of the legal capacity of same-sex partners and of sexual minorities in Canada has been something that I would call the opposite sex movement. In 1974, as the result of recommendations contained in the Royal Commission on the Status of Women, the Veterans Act was amended to include the term opposite sex when describing the cohabitants who could qualify as war brides for pension benefits under the Veterans Act. The Veterans Act had previously had a common law spouse category, which was expressed in terms of sex-neutral terms. Coincidentally, in 1974, we also had the specter in Boulder, Colorado, of people rolling into county clerk's offices and saying, "We'd like a marriage license, please." And the county clerk saying, "Oh, there's nothing in this statute that says no homosexuals," because it simply used the words persons. So in 1974, you had the specter of people getting married in Boulder, Colorado with perfectly valid marriage licenses. And you also had the North and Matheson case, which was being decided in Canada. So the federal parliament decided, better put the words opposite sex into the definition of cohabitants in the Veterans Act. And shortly thereafter, omnibus legislation that was adopted by the federal government began to insert those two little words into every statute that it took up for anything. And if you just amuse yourself someday, go do a QL search on opposite sex. It's like this little sort of legislative virus that has spread across the country, to the extent that by the time the problem with the human rights codes, which is that they protected against discrimination on the basis of sex, but not on the basis of sexual orientation, was amended to include sexual orientation, you had the Ontario legislature also sliding in there with Ian Scott making this speech, right, the words opposite sex in the definition of spouse in the Human Rights Code. And right there in Hansard, you have Ian Scott saying, there's nothing in this legislation that's going to interfere with the traditional definition of marriage. So, for a long time in Canada, we've already had a more muted version of the defense of marriage type of act going on, and that's the opposite sex movement. So you add all of these things up together, and you got a position described on pages 3 and 4 of the notes in your binder, showing that in pre-charter law, there was a vast number of situations in which sexual minorities, predominantly lesbians and gays, but by no means exclusively lesbians and gays, because you had lots of transgender and transsexual people who were litigating right along with lesbians and gays, being told that they did not have a wide variety of rights. And these rights all boiled down to the denial of different forms of legal capacity. Now, that was the past. Things look like they've changed. How did it happen? We can identify a couple of factors that have resulted in changes. The Charter of Rights absolutely has to be the key thing that has resulted in the transformation of the jurisprudential scene in Canada. It resulted, first of all, in the insertion of sexual orientation into the Ontario Human Rights Statute. At least the government of which Ian Scott was a member was able to convince people that the Charter required them to put the word sexual orientation into the Human Rights Code in Ontario in 1986. But secondly, probably more importantly, although I'm by no means saying that that was an insignificant development, the Andrews test of discrimination, the Oakes criteria for application of Section 1 of the Charter, the demonstrable justification clause, did eventually displace both the morality presumption and the heterosexual presumption that had riddled pre-charter law, and replaced those presumptions, which themselves were based on prejudice and stereotype, with objective criteria that led quite quickly, in cases like the Vasey case, to a number of breakthroughs. One was a court just simply saying, you know, hey, we look at this family visiting policy that Corrections Canada had produced, and we don't see how it excludes same-sex partners. So you suddenly had judges sort of reading sexuality-neutral legislation as if it included same-sex partners, to the extent that I would almost say that the Vasey case could be seen as the person's case of queer law in Canada. Secondly, in the Vasey case, you had the court going through the Andrews criteria and saying, you know, well, this is probably all true, you know, these problems with capacity, the problems with biology, the problems with morality, but they said, you know, look, it says here in Andrews, you know, is this a disadvantaged group? Is this discrimination? Does this legislation burden? So the court just sort of went down the checklist and they got to the bottom of it and they said, you know, oh, this violates the Charter. And from then on, you had sort of a snowball effect where court after court quoted Vasey, then the next case, the Knodel case in BC was quoted, and so on, until you got to what I consider to be probably one of the most important cases in Canada, the Hagen-Birch case, in which the Ontario Court of Appeal agreed that the Charter was powerful enough to put sexual orientation into human rights codes that didn't already have it. And that, of course, was the federal statute. That then accelerated into the decision in the Leshner case, which pushed into the area of private rights, contractual rights, recognition of relationships, and so on. And the cases began to move in a direction that was simply not possible before the Charter was enacted. So that brings us to the question of today: are we persons yet? A number of people have offered answers that sort of fall generally in the area of, I'll call it sort of, or getting there, with the caveat that I'm using this in the classical jurisprudential sense. I'm not going to go in that direction. I'm going to say no, we're not persons yet. We are absolutely not persons yet. It may be that it's starting to look like it. There's the M&H case, absolutely the most wonderful decision by the Supreme Court of Canada I've ever read. There's Bill 32 in Quebec. There's the British Columbia Family Relations Act. There's the British Columbia Law Institute recommendations for registered domestic partnership legislation, and an increasing number of successful cases at the administrative, grievance, judicial level, etc. But the problem is, and this is the problem that is illustrated by the appendix at the end of the notes in your binder, the problem is that if you break the classical incidence of legal personality down into the two fundamental categories of individual or personal rights, such as the Vriend case, in which there was the right to go to a human rights commission or the right to employment, versus relational rights, then you see that we're actually doing pretty well on the sort of individual or personal rights. But when it comes to the relational rights and all of the factors that they include, there is still a tremendous gap in the law, because legal personality, full legal capacity, consists of both personal rights and relational rights. Now, the core problem, and we've touched on this in a number of different ways already, so it's pretty obvious, with the recognition of relational rights is the continuing denial of the right to marry, because it has a cascading effect on a number of other rights that can be allocated under the current legal system. This cascading effect sort of flows partly into the whole marital property regime system that you find in each jurisdiction. The cascading effect also goes and touches all of the rules that relate to the determination of the parent-child status, or the status of a child with same-sex parents. And it also goes into all of the areas of statutory and private law, everything from tax credits, tax deductions, to insurance, pension rights, and so on. Now, it's a little bit confusing, I admit, because the expansion of cohabitation rights, the expansion of the definition of cohabitant, the attack on the opposite sex qualification for recognition of cohabitation, has begun to blur the effect of excluding same-sex partners from the institution of marriage. But take a close look at what's happening with the cohabitation rules. There is no jurisdiction in Canada, indeed there is no jurisdiction in the world, where same-sex partners have every single right and responsibility of recognized cohabitants. There are hundreds of such provisions in each jurisdiction, and although some of the omnibus statutes, such as the Quebec statute, touch a lot of those, they don't begin to touch all of them. They're going very much in an incremental or piecemeal fashion. But even in jurisdictions where cohabitation is a so-called free state, such as Quebec, cohabitants have no legal status under the Quebec Civil Code, which regulates the incidence of marriage. Yes, there are Quebec statutes, such as insurance statutes, that recognize cohabitation, but not the Quebec Civil Code, which has to do with marital regimes. Even in the free state in which cohabitants live in Quebec, they have genuine freedom. They have the freedom to marry. But the cohabitation that is being extended to same-sex partners is not that free estate, because there is no right to elect to marry. And if you read marriage legislation, you find that sexuality is still just as much an incapacity as being a minor, being too mentally incapacitated or incompetent to contract marriage, or it is as incapacitating as already being married to someone else. So in terms of legal capacity, I would say that same-sex couples and sexual minorities generally are not full legal persons. Now, in these notes, I have described this movement toward registered domestic partnerships as a threat, as something that may well actually put the current sort of trend toward success, may slow it down, may create problems. And that is because if you take a look at registered domestic partnerships, take a close look at them, nowhere in the world does a registered domestic partnership set up anything but either second-class or third-class relationship recognition. And nowhere, I think I will say, as a hypothesis at least, has the second or third-class status conferred by registered domestic partnerships been at the request of lesbian or gay communities. The example that people usually look to first is the domestic partnership model that you find in Denmark. And I'll just run through what some of the problems with that model are, because that is sort of the analytic starting point for those who are interested in this legislative model. First of all, in Denmark, couples who want to enter into a registered domestic partnership have to register at civil offices. They are prohibited from having a religious ceremony. The reason for this is because of the immorality that is associated with same-sex conduct in Denmark. They are therefore denied access to clerical mediation, which is considered to be one of the big forms of conflict resolution in the matrimonial area. Lesbian couples do not have the right to artificial insemination. Same-sex couples may not jointly adopt children. A same-sex registered partner is not considered to be a single person for purposes of adoption, so that is not an option either. If, despite all of these rules, a same-sex couple does come to have a child or two, and it has happened, and if they break up, they are not legally permitted to have joint custody of any child that may be considered to be their child. And just to make things perfectly clear, there is no possible recognition of parental status between the non-legal parent of such a child. In addition, both people involved in a same-sex registered partnership have to be citizens and residents, a limitation on marriage rights that would be really unheard of in other jurisdictions. There are some variations on this model in Europe, but nowhere are all of these disabilities or incapacities eliminated. And I would go so far as to say that this new system that has been proposed in France, which is called the PACS, actually sets up a system that rigidly segregates same-sex registered partnerships and marriages. There is no cohabitation recognized for heterosexual couples. So in France, you simply have formal marriage for heterosexuals and the PACS, or a registered union for same-sex couples, and opposite-sex couples cannot qualify for that. British Columbia, in the form of the Law Institute, has recently proposed a registered domestic partnership model, which, although it does not prohibit access to artificial insemination, that right has been secured as the result of a tribunal decision, Benson and Korn in BC. Nonetheless, this is a variation on the registered partnership model, which I don't know. I guess I have a hard time describing it seriously. It's the any two adults can register model of domestic partnerships. 2 roommates, 2 friends, 2 siblings, a parent and a child, tennis partners can register their partnership and can thereby acquire all of the rights and responsibilities of marriage, including a forced share of the deceased partner's estate, a forced share of the partnership home, a share of the net partnership estate, rights to support, the right to renounce a will, and so on, can be claimed as the result of registration under the British Columbia model. It is also possible to register secretly for all of those same-sex partners who have been out there so busily agitating for political change that they forgot to tell their parents or something. None of this, however, has changed the step-parent classification to which same-sex parents are assigned. And all of the rights of cohabitation are still not available as the result of this legislation. It's a modification of the French Pax model in the sense that in BC you have 3 categories. You have heterosexual marriage, you have the anybody, any 2 adult human beings with legal capacity, can register as domestic partners, and then you also have the category of sort of conjugal marriage-like cohabitation. And same-sex partners can choose from cohabitation and registered partnerships. Heterosexuals can choose from all 3 forms, and of course, tennis partners can choose the registered partnership model. I would go on, but the basic point that I think is very clear when you take a look at registered domestic partnership legislation as it has evolved around the globe is that essentially all of these statutes appear to offer relationship recognition, and they do solve some immediate short-term problems with less paperwork than was previously available, but they all strengthen the marriage bar. And from the point of view of the Canadian context, I consider them to actually be dangerous because a jurisdiction that has adopted a registered partnership model can look, when defending itself against a suit for denial of marriage rights, to its registered domestic partnership model and say, as did Judge Sapinka in the Egan and Nesbitt case, you know, this is an incremental reform in the process of gradual recognition of da-da-da-da, and it is demonstrably justifiable in free and democratic societies, such as Denmark, Sweden, etc. So I think that they all form a serious threat, and I think that they help emphasize that when you're filling in sort of the little chart at the end of these notes, help emphasize the fact that the right to marry column continues to be completely blank. Now, I'm not advocating marriage for anybody. I think, however, that it's just fine to have the right to marry and not exercise that right. I think that the great discrimination here, the great denial of capacity, is the denial of the right to choose whether or not to marry. And in order to just emphasize why I think that this is a very important aspect of the sort of long-term civil rights struggle that sexual minorities have been involved in, I'd like to just point out some of the parallels, again, in the United States that emerged after the Emancipation Proclamation was declared, to help sort of just give a comparison to what seems to be happening with lesbians and gays today. Before the Emancipation Proclamation, slave codes prohibited marriage absolutely, and slaves did not have right to custody to their children, and needless to say, nor to access to their children. After the war, statutes were passed called Civil Rights Act, declaring that former slaves were persons, declaring that they were emancipated, and spelling out all of the civil rights that they then had. Usually those lists included maybe 2 or 3 things. And then the list followed of the things that they still did not have, such as the right to own real property or the right to move around freely in their own communities. But one of the rights that they were given was the right to marry. It was a very odd form of marriage. They had the right to register at the local city clerk's office, and they were applied to marriage in the form of anti-miscegenation laws. Something like 35 states in the United States eventually enacted laws that made it a criminal offense to marry across what was considered to be the racial bar, and religious justifications of the most profound kind were offered for this anti-miscegenation legislation. 101 years after the Emancipation Proclamation was put into effect, the Supreme Court of the United States did declare that those anti-miscegenation laws did violate the Equal Protection Clause of the 14th Amendment to the United States Constitution, but it took quite a long time before social attitudes sort of began to change in accord with those kinds of decisions. Now, I think it's very easy to say that registered domestic partnerships or even omnibus legislation that gives partial recognition by assimilating same-sex partners to the status of cohabitant is an improvement. But the other problem with it is that it is totally segregating. It creates complete segregation in the law. It is separate and it is not equal. I think that there's absolutely no basis for claiming that it is equal. Now, where does this leave us? Well, I think that, to get very quickly to my last point, where this leaves us is in a very difficult position. British Columbia will be looking at its legislation very quickly, I think. M&H has sort of lit a fire that is going to spur that on. The Ontario government has until November 20th to do something. And what? Will it look like Bill 167, which left same-sex partners out of all of the marriage rules? Or will it look like a registered domestic partnership? It's going to look like one of the two. There are no other models out there. The Law Commission of Canada has funded a major conference to be held at Queen's University on the advantages of domestic registered partnerships for Canada. I didn't organize it. And it does have a session on other alternatives to registered domestic partnerships. But I think that that's a pretty good signal for people who are looking for signals that registered domestic partnership legislation is looking pretty attractive to parliamentarians. Now, there is a little bit of light at the end of the tunnel. The chairs of this CBO committee have decided that they are going to schedule a large working session in September, which will basically be set up as a consultative meeting in which people who are concerned about the legal capacities of sexual minorities in Ontario can give their opinions on what forms of legislative recognition they would like to see. So I urge you to tell everyone about this meeting and come to it being prepared to get involved, because I think that it's probably going to be the best chance to try to head off the insertion of legislation into Ontario statutes that will be very difficult to fight when we're down to the Section 1 Oakes test. That's all I have to say.